I want to now move to a married person because you would think that with a married person it is easier. And frankly, it is and it isn't. And I'll explain why. So let's go to a married person. Yes, you're married. Do you have any living descendants? So the answer in this case is yes, you do. See this where it says your spouse then gets 100% of CP, that stands for community property. 50% of the SP, separate property. Sorry, I couldn't spell it out. There wasn't enough room. And descendants get 50% of the separate property. All right, this is confusing. Let me back up a little bit. In the state of Washington, we are a community property state. What that means is during your marriage, everything that comes to you from your earnings, from the work that you do, is what we call community property. So let's say one person's a stay-home spouse, the other is the wage earner. It doesn't matter. It's all owned as a community, 50-50. Let's say that you receive an inheritance directly from your parent or your aunt or somebody. That's called separate property. Any kind of gift to you or an inheritance to you is separate property. So separate property, recall, goes half to your spouse, half to your descendants. Community property goes all to your spouse. So what happens is that when a person doesn't have a will and there are children from a prior marriage in particular, what happens is that there is going to be a lot of dispute typically about what is considered community property and what is considered separate property. And I encounter this quite a bit. People who maybe they did receive an inheritance, so it's separate property, but they took that inheritance and then maybe what they did was maybe they inherited a house from their parent, but the house had a mortgage on it. So now they're starting to pay the mortgage from their wages. That is changing the character of that house from separate property to community property because it is commingling. We're putting community funds into the house to pay the debt on it. So it's not 100% separate property anymore. It's becoming community property. So anytime wages are used to pay debt on a piece of separate property, then there's going to need to be some finding of fact by the court in a probate process to say how much of this is separate, how much of it is community, and divvy it up accordingly. So the community, the separate property piece of it is really what lends itself to dispute, to litigation, to costs. And, the more that's involved, the more likely that there is going to be a dispute because people are looking after their own interests. How do you solve for this? A couple of ways. You can have a will that says where everything goes. Another way is commonly when people get an estate plan done, they might do a property status agreement, which says, for example, everything I own is owned by my spouse and me, and when I die, everything goes under my will. Lots of times community property agreements say, when I die, everything goes to my spouse. We're not as fond of those here at ELG Estate Planning because then that might take away the protections that exist in a will. And I'm not going to get into that today, but you can characterize what your property is. You, for example, can say in a property status agreement, everything is community except for the house that I inherited from my mom, or something like that, to make it really clear what's separate, what's community. But you still need to make sure that you're not putting community funds into it unless you have an agreement with your spouse that asset will remain separate property. Why am I spending so much time on this? The reason is this is where all the disputes come up between a surviving spouse and children from a prior marriage, based on the fact that Washington state says community property goes 100% to the surviving spouse, and half of the separate property goes to the surviving spouse, half goes and is divided among the descendants of the deceased spouse. So it is definitely a great opportunity for litigators to get involved in. Oftentimes there's litigation. And I got to tell you, as an estate planning lawyer, and especially one that used to do litigation many, many years ago, we do everything to avoid litigation. It is costly and it is not anything that anybody wants when it comes to estate planning. Okay, I'm going to share my screen again. I was just talking about you're married, you have living descendants, what happens to your assets? Okay, so let's say you're married and you have no kids. Then the question is, are your parents alive, one or both? Now look what happens here. Yeah, your parents are alive. Same question, same thing on this community property split, but it's a little bit different. Your spouse again gets all your community property, but your parents get some of your separate property, 25% only, and the spouse gets 75%. But you can see there's this opportunity for dispute and litigation, though it's not nearly as much as when you got the kids involved. All right, let's say your parents aren't alive. Okay, do your parents have any living descendants? Yeah? Well, then guess what? The parents' descendants get 25% of the separate property, not the parents. All right. Let's say no, your parents don't have any living descendants, then yay, your spouse gets 100% of everything. So that is the estate plan that Washington has for you when it comes to where does your stuff go? Where does your money go? Where do your assets go if you don't have a will?